this area of receivership and liquidation, I had actually introduced what is a receivership. I was able to explain, and I think you can be able to catch up with the video. So kindly catch up with the video if you are not in class. What we learned about a receivership introductory part, and of course also introductory part of liquidation part. So we left at the point where we were supposed to start looking at the powers and duties of the liquidator, and then we can be able to look at what we call voluntary liquidation. So I won't do so much of a recap because I basically can go back to the videos and try to catch up with what we had actually covered. So you're supposed to start from here, and I think I left it as an assignment so that you go and actually basically do like a self-study about what are the powers and duties of a liquidator. So hope you're able to look at them. So but now in this case, we can just do a recap. Then of course we can start on voluntary liquidation. So the powers of the liquidator. So these liquidators you are saying initially, the liquidator can actually be appointed by the court. So there are those powers sanctioned. There are those powers sanctioned or basically provided for by the court. So part of the powers in this case include sanctioned by the court include, for example, to institute or defend any suit in the name of and on behalf of the company. In this case, the liquidator will be like the one who's actually in charge of like everything within the company. So when the company is actually under liquidation, so he'll be the person to go to, he'll be the person to undertake all the processes pertaining to the company. So in any case, there's any kind of action that has to be brought for the company or defend any kind of suit against the company, then it will be that liquidator will likely basically be there to do that on behalf of the company. And then to carry on business of the company so far as may be necessary for the beneficial winding up of the company. So you are saying automatically when the liquidator is actually appointed that the top level management will lose their positions, that is the board of directors. But now in this case, the employees can end up having to be retained so far as it is necessary for the beneficial winding up of the company. Probably they are basically having to be wanted there to be there to liquidate. There's need for them to be there to liquidate the inventories. There's need for them to be there to liquidate the inventories. So the inventories are supposed to be sold, they get money to be part of what would be the resources for liquidation. So they can still be maintained there, so for the beneficial winding up of the company. Then number 3, to raise any money as may be required and charge the company's assets as far as possible. So he can be able to raise any form of money so far as he feels it is actually deemed fit to facilitate or enable the liquidation of the company. To appoint an advocate to appear before the courts to assist on any form of litigation against the company or assist him in having to perform part of his duties. Then to pay any class of creditors full or to make a compromise or an arrangement with the creditors. So we've already learned about compromises. So he basically can be able to enter into some kind of like arrangements with the creditors. And basically come up with the compromises and arrangements whereby they can end up having to turn from the debtors and actually become what? Shareholder. Creditors and actually become shareholders. It is some
group accounts presented before holding company.
Yes, I think I've muted some to group. So he can basically be the one in charge of having to come up or make those kind of arrangements. So then to compromise calls, debts, and other pecuniary liabilities which are basically to the contributories or maybe debtors. Then to do all such other things as may be necessary for the winding up of the affairs of the company and distributing its assets, e.g., settling a list of contributories and actually creditors. Then we have powers without the court sanction. So these are basically powers without the sanction of the court. So the court doesn't have to, for example, provide these as powers to the liquidator, but of course they can still be powers of the liquidator. So to do all acts in the name of or on behalf of the company and to execute deeds in the name of the company. These are basically like kind of like agreements So he'd be the one in this case who would be in charge of having to execute agreements on behalf of the company. Remember, a company is an artificial person, so it cannot be able to sign. So who will be signing on behalf of the company when directors are not there during liquidation? It is the liquidator. Then to inspect the records and returns of the company and the files of the registrar without payment of any fee. Then to draw, accept, and actually endorse any negotiable instrument. Negotiable instruments are like, for example, checks. So he has that right to draw them and negotiate them. Then to make out in his official name letters of administration in an estate of a deceased contributory, and to do necessary things to obtain what? Payment. If there's actually any pending payment from a contributory, then he can be able to follow up to the estate of that particular contributory. Then to appoint an agent to do any business which he is actually unable to do. So he can basically appoint someone to assist him in those kind of issues he's not able to do by himself. Then to prove rank and claim in the insolvency of any contributory or for any balance against his estate. Then to set aside fraudulent preferences effected, for example, 6 months before the commencement of liquidation. So those are basically part of the powers not sanctioned by the court. Then you have the duties. The duties, basically, most of them are just in relation to the powers. So in fact, they are derived from the powers. To conduct the liquidation proceedings and perform such duties as the court may impose. Then to submit a preliminary report to the courts after receipt of the statement of affairs, because the thing initially, when the liquidation is to start, he'll get like a statement that is indicating the affairs of the company to be liquidated in terms of what are the assets, what are the liabilities, who are the creditors, what are the expenses due, like that, what are the incomes expected. To take into custody all the books and documents and assets of the company, to give regard to the resolutions of the creditors or contributories, or to any direction given by the liquidation committee. Then to summon meetings of creditors and actually contributors. Contributors are basically the shareholders. Then to maintain proper books in the prescribed manner and to record entries and actually minutes of proceedings of all the meetings that could end up having to happen during liquidation. Then to present an account of the receipts and payments to the courts, what he has already been able to pay, what has already been able to receive over a particular period of time. Then to give out or submit all the concerning information, necessary information that is on any pending liquidation where the process is not concluded within a year. So if it goes beyond 1 year, then he'll be preparing a report at the end of each and every year to submit the relevant parties, who could actually basically be, for example, the court. So we have the last type of liquidation, we call it voluntary winding up. So this one is normally categorized into two, as I had already indicated in our previous class. So we can have voluntary winding up by the members, or we can have voluntary winding up by creditors. We can have voluntary winding up by the members or voluntary winding up by the creditors. So just a minute. So as you're saying, under voluntary winding up, we can have two ways. So you can have voluntary winding up by members and voluntary winding up by creditors. So the option under which, so as you can be able to just to see from the term, it is voluntary. It is voluntary. So it is where the company voluntarily is wound up. Remember the other one we're having to look at, it is by the court, or sometimes we call it compulsory. So it is where the court has been forced to, the court basically, under the circumstances provided, it has decided the company will be compulsorily be liquidated. So it gives an order for liquidation. But under voluntary, it is voluntary. So there's no, for example, having to force the company to be liquidated. But voluntarily, it is just that in this case the company wants to be wound up or be liquidated. It could be due to a number of factors. For example, it could be maybe the objective under which the company was actually formed has already been met. So there's no essence for the company to continue to be in existence. So it voluntarily decides it is going to be liquidated. So if the objective was actually already met, or maybe it was just basically formed for a particular period of time, and the period has actually elapsed, so it can be voluntarily be liquidated. If in this case, it is maybe what we call reconstruction. It is exactly what we call reconstruction. And of course, now in this case, you're having to move the operations to another company, so it can be voluntarily be liquidated. So like that, it can be voluntarily be liquidated. So under which option they are going to choose to liquidate, there's normally the determination of what we call the solvency of the company. The solvency of the company. There's normally what we call the solvency of the company. The solvency of the company. So if the company is solvent, solvent simply means they have money. So they can be able to meet their obligations within the short term. So that's when they go for the voluntary winding up by members. I don't know if you are very keen to what I'm having to say. So I'm saying if the company is solvent, that in this case, they have enough resources, they can be able to pay up their liabilities within the short term, within a very short period of time, that is not beyond 1 year. Inamaanisha wako na chapa, wako na pesa, wako na do. So that simply means what will happen, they'll go for the option of voluntary winding up by members. But if the company is insolvent, it doesn't have money. It simply means that they cannot be able to meet their obligations in the short term, in the shortest time possible, that is within like a year. Then they'll go for the option of winding up by creditors, whereby they'll have to involve the creditors who are supposed to be paid. But now the company doesn't have money, so it will end up having to arrange or make plans for itself beyond a year. It maybe sells off its assets and get money to pay what the creditors. So if the company is insolvent, they don't have enough resources to pay the liabilities immediately. So what will happen here, it is that they go for the option of voluntary winding up by creditors. So voluntary winding up by members, there has been an assessment by the board of directors, by the management. They have realized that in this case, the company has money, so it is solvent. If it is solvent, they'll go for voluntary winding up by members. They don't have to involve the creditors. If it is insolvent, it doesn't have enough resources to meet its obligations in the short term or within a period of a year. That simply means in this case, they'll go for the option of having to winding up, known as what? By creditors. So once they have been able to determine the solvency and the insolvency of the company and they have chosen the option, it simply means that in this case, what will happen, if it is voluntary winding up by members, the company or the board of directors will end up having to convene a meeting of the members of the company. And then in that meeting of the members of the company is where the appointment of the liquidator will happen. And of course, that is where also they'll be able to set the remuneration for the liquidator. So if the company is solvent, it will be voluntary winding up by members. The company will convene a meeting of members. Under that particular meeting, they'll be able to appoint a liquidator as the members and of course set what will basically be the remuneration of that particular liquidator. If it is voluntary winding up by creditors, that is the option they are going to go for because the company is insolvent. And then they'll convene, the directors will likely convene a meeting of the creditors. Then at that meeting of the creditors, is where the liquidator will likely be appointed. And of course, also his remuneration will do what? Will be set. So that's basically what will happen under the two options. So once the liquidator is appointed either way, then the liquidator will be able to do what? Gather all the assets. And of course, will basically provide a report as to how far he has been able to cover in terms of having to pay expenses and liabilities within a period of a year. So he has to prepare like a report after the end of each and every year to just indicate as to how far he has been able to undertake what? The liquidation. So if it is in this case the members who appointed him, then that means that in this case this report will have to go to the members and indicate clearly as to how far he has actually been able to undertake what? The liquidation. If it was a voluntary liquidation by creditors and he was actually appointed by creditors, he'll prepare a report at the end of each and every year as far as how the liquidation has actually been undertaken, and of course present to who? The creditors. Then overall, once liquidation has actually come to an end, that probably all the expenses, all the liabilities have actually been settled. What normally happens is that there'll be a preparation of a liquidation report. This one can actually basically be either if it is maybe compulsory or voluntary, there'll be a preparation of what we call a liquidation report. And of course, now in this case, the liquidation report will be presented to the Register of Companies. It will be presented to the Register of Companies. Then once the Register of Companies receives the liquidation report, he'll be able to ascertain by himself that in this case, there has been a proper undertaking in terms of liquidation or liquidating the company. And therefore, what he does, he strikes off the name of the company from the register at the registrar's office. And after that, the company would have died completely. But remember, when the company is still having to undergo liquidation, it is a separate legal entity, and therefore it can still be recognized to be a person. You can be able to sue it, or it can sue you. And of course, it can be able to enter into contracts, or in this case, it can be able to do what? Maybe enter into any other relevant agreements. But once that dissolution has happened, the registrar has gotten the report alluding to a proper liquidation having been undertaken, then he'll have no option but in this case to do it, to strike off the name from the registrar's office, and that simply means that will be the dissolution of the company, because in this case it would have died. In quotes, it would have died completely. It would have died completely. But if it is still under liquidation, you can still recognize it as what? As a person. As a person. So that's basically what normally happens under voluntary liquidation. So we can have voluntary liquidation by members or voluntary liquidation by creditors. By members or by creditors. So distribution of assets be done. Because once it is done, so that simply means the creditors' dues will have to be settled. Then of course the assets that will basically remain as residues will be shared amongst the shareholders of the company. Then eventually the company can be dissolved. It can be dissolved by simply having to present a liquidation report at the registrar's office. If it is quite okay as to how the liquidation has been undertaken, the registrar is satisfied. As you're saying, you'll end up having to remove the name of the company from the registrar's office, and of course, we'll be able to say the company has completely died or it has basically been dissolved. Dissolution has actually happened. So we can have what we call early dissolution. So you don't have to go into this kind of hullabaloo of having to come up with the TDLs or liquidation committees. But in this case, there can be what we call an early dissolution of a company. So this happens when an order of liquidation of a company has been made by the court, and the official receiver is the liquidator of the company. And what has happened? This official receiver, maybe liquidator, is satisfied that in this case, that the realizable assets of the company are insufficient to cover the expenses of liquidation. So there is not even asset to recover. So it is quite minimal. It can't even meet what? The liquidation expenses. So that can be an indicator of what? Just having to undertake an early dissolution. And then that the affairs of the company do not require any further investigation. So the official receiver may apply to the registrar for an early dissolution of the company. You don't have to go into a lot of affairs or distributing assets or what. So it is very simple. So they have already been able to settle all their liabilities. So there's no essence of having to go into those long, tedious processes but there can be an early dissolution of the company. So that's what can end up having to lead to what we call early dissolution of the company. Early dissolution of the company. So ideally that marks the end of this topic, receivership and early liquidation. So I just want us to start the new area. So I want us to start the new area. That is topic number 10. Let me open it. But as I open it, we can take a break of 2 minutes. 2 minutes, water break of 2 minutes. Then when you basically are fresh now, we can start. Yes, welcome. So I think we can proceed. Is it okay if we proceed? Bridget Mose. Is it okay if we proceed? So I can see Kezia Mumbi says yes. We can of course proceed. We can of course proceed. Yeah, so we can look at this one. So I want us to wind up with it. Then we can say pray to the syllabus coverage. So topic, this particular topic, I think there we have combined 2 areas. So you have what you call company accounts, then audit and investigations. So you have company accounts and audit and investigations. So under company accounts, so this one is what you've just gotten used to. So you've learned financial accounting somewhere, you've learned financial reporting somewhere, then this is what you've just gotten used to. So under this topic, we just talk about the kind of accounts that can actually be maintained by the company. So we have the financial statements, which basically comprise of maybe the income statement, statement of financial position. So of course, there are other reports that are supposed to be maintained by the companies, especially listed companies. For example, we have directors' reports. We have reports of the remuneration of directors, so they have to be provided. So all these ones, the company is actually called upon to be able to maintain them. And of course, in this case, when you talk about, for example, the income statement, then you must be able to know, for example, what are the elements or components of an income statement, and what could be the reason as to why, in this case, an income statement will end up having to be prepared in a company. So that is very simple, to be able to know the profit and loss, to be able to know the retained earnings, to be able to know, for example, what has been transferred maybe to the reserves, to be able to know, for example, what could be the expenses that have been incurred by the company over a particular period of time, to be able to know the incomes that have been realized by the company over a particular period of time. So if they ask what is basically the essence of preparing to an income statement, you can't miss out, write something. You can't miss out, write something. So as a safeguard to creditors, investors and shareholders, there is a statutory obligation placed upon every company to keep proper books of accounts and to make an annual return to the registrar, giving certain information regarding the financial position. So the books must give a true and fair view of the state of the company's affairs and to explain the transactions undertaken in these books of accounts. So the annual financial statement in relation to a company means the company's individual financial statements for a financial year and includes any group financial statement prepared by the company for that particular year. So now in this case, if it is a company that is not quoted or listed on the stock exchange, then what is basically called upon to be able to prepare in terms of its financial statements will include, and financial reports will include, for example, the annual statement of financial position, the annual statement of financial position, and of course the annual statement of income. It has to be prepared. There has to be a director's report. In the director's report, they'll give a report about, for example, the prospects of the company for the future. So because they're the ones in this case who formulate what the strategies. So they're involved in strategic management of the company. They formulate the strategies. So here it simply means that in the director's report, they have to indicate or highlight what they're having to do with regard to the company for the future, or in the future, how the company will be. So if it is unquoted, then you have to prepare the annual financial statements that the director's report just tried to describe. Then also there has to be an auditor's report on the financial statements and the director's report unless the company is exempted from audit. If it is a quoted company, then you'll have the directors, you'll have the annual financial statements, that is the income statement, and of course, statement of financial position. You'll have the director's remuneration report, you'll have the director's report, you'll have the auditor's report. So that is the annual, the financial statement. The auditable part of the director's remuneration has to be there. Then, of course, the director's report. So they can ask this one in the exam. So the quoted companies, which are kind of the financial statements you must be able to prepare or maintain, or kind of reports to be maintained. So you must be able to indicate those ones. So the books of accounts, as we've already been able to indicate, majorly here we are talking about the statement of financial position, and of course, you know the components of what is normally contained there. You also know what we mean by a statement of income, sometimes known as what the P&L, profit and loss account. Statement of financial position, sometimes known as what? The balance sheet. Sometimes known as what? The balance sheet. So if it is a group, then you'll be called upon to prepare the consolidated financial statements. If it is a group, what do you mean by a group? Whereby we have a holding company and its subsidiaries or maybe associates. So if that is the case, then you'll have to do what? Consolidate. You'll have to do what? Maybe consolidate. You'll have to consolidate. So companies exempted from audit, so we can people talk about in this case, maybe we can talk about maybe, so for all public companies, we say it is mandatory for them to ensure that their books of accounts have been audited. But now private companies, so sometimes they are normally exempted. So private companies are exempted unless, for example, this company is involved in banking or insurance business, then it is mandatory for the books of accounts to be audited. So for public companies, mandatory. Private companies, it is optional, not mandatory for the books of accounts to be audited. But in this case, private companies will just be forced to ensure that their books of accounts have been audited due to a number of factors or a number of reasons, including, for example, each and every year they have to, for example, make the annual returns. They have to make the annual returns to the taxman. So in this case, before they make the returns, there has to be a reliance upon what they have been able to make as an income, or maybe this is what they have as assets. And of course, this one can only be certified by a qualified auditor. But generally, under the statute or under the Companies Act, so there's no provision for private companies to mandatorily ensure that their books of accounts have been audited. So private companies are exempt, but public companies mandatory. But that exemption rule for private companies doesn't apply in situations whereby the private company is involved in, for example, maybe banking or insurance business. Banking or insurance business. So what if the company is not quoted? Which reports should be? They keep so out. It is actually indicated here. Let's see. The companies are quoted in their these ones. If it is unquoted, they are these ones. So you are together. If it is unquoted, these ones. If it is quoted, these ones. Yes, you can be able to see I've highlighted there. So it is a critical area. It is a dangerous mental area, so it must be killed because it can be tested. It can be tested, that one. So as I was trying to explain, that in this case, if it is a group, then there will be the requirement that they prepare the consolidated financial statements. Consolidated financial statements in this case are what they basically comprise of the financial statements of the holding company and those ones of the subsidiaries or maybe associates. The subsidiaries or maybe associates. So they'll have to consolidate. But there's that situation or maybe circumstance whereby companies that are supposed to prepare these group accounts can be exempted. So from having to prepare them. So they can be exempted from having to prepare them. So the reasons, so I think we looked at it some time back. So the reasons could be, for example, if the financial statements could be misleading or confusing, then you don't have to prepare what the consolidated financial statements. So if it is impracticable or it will be of no value to the members of the company, then you don't have to consolidate. Or you can basically seek for exemption from consolidation. Or number two, it could be the results would be misleading or maybe confusing when they undertake what the consolidation. Or it could be if the business of the holding company differs from that of the subsidiary to such an extent that they can't reasonably be treated as a single undertaking. So they can't be reasonably be treated as a single undertaking. So they are very operating in completely two different businesses. So this one I think I was able to explain in a particular division we've done just recently. So you should be having like a hint. So the group accounts, you simply mean that the consolidated financial statements comprising the holding and subsidiary company. That is basically what the Companies Act calls upon. Those ones in such kind of arrangements to ensure that has been done. But in this case, as you are saying, there can be exemption rules whereby it is not mandatory that in this case you consolidate. There could be a number of reasons that could end up having to hinder you or hamper your consolidation. When you present these kind of reasons, then you can actually be exempted from having to prepare the consolidated financial statements or the group accounts. So you must take note of these particular exemption rules, because you can see I've highlighted them. So you need to be very keen. Need to be very keen there. So circumstances under which a company can be exempted from the preparation of the consolidated financial statements. So of course, the consolidated financial statements will likely comprise of what? It will comprise of what we call the consolidated income statement. It will comprise of the consolidated statement of financial position. It will comprise of maybe the consolidated statement of cash flows. All those ones will be part of the consolidated financial statement. And if a company is a group, then that is what the Companies Act calls upon to be prepared as what? Financial statements. So the contents, it will have the group balance sheet, it will have the contents of our group accounts, or sometimes we call them consolidated accounts. So it will have what we call the consolidated balance sheet or statement of financial position. They will have what we call this term has to be there, consolidated. They'll have the consolidated P&L, sometimes we call it what? The consolidated income statement. So when the financial years of a group of a company do not coincide, the registrar may relieve the holding company or the subsidiary company from holding an AGM in a calendar year where it is desirable to extend a financial year to coincide with that of the subsidiary. There must also be attached to the holding company's books laid before the annual general meeting a report on the directors. So there is normally a report of the directors. As you're saying, it is normally presented together with the financial statements to the members at the AGM. So if in this case it is a holding company, then the report having to be presented must basically show the state of the company's affairs, the amount, if any, they recommend to be paid as dividends. So the amount, if any, they propose to carry to reserves. So a fair review of the business during the year, and at the end of the year, the names of who are directors, then details of any acquisition by the company of its own shares, then directors' interests in the shares or debentures of the company at the beginning and at the end of the year, if not shown elsewhere in the accounts, if not shown elsewhere in the accounts. So there's an annual return that is normally prepared by the company secretary. I think there's that one we were able to allude to it, or maybe we were able to elaborate or maybe explain briefly when we were looking at the topic of a company secretary. So there's a return we alluded to that in this case it is normally prepared and of course submitted to the register of companies each and every year. So this return then it basically has certain contents or maybe components. So that's what I want us to look at. Under the Companies Act, it states that every company having a share capital must file an annual return or annual report with the Register of Companies. The return shall consist of information required to be given to the registrar at the end of the year. So the return must be prepared and filed with the registrar within 28 days after the date to which the return is actually made up. If a company fails to lodge an annual return required to the Register of Companies, then he risks having to be penalized a fine of up to 200,000. 200,000. So if you fail to remit, you can actually be penalized. So this annual return what is normally contained there, part of what you can be able to mention, it normally has the address of the registered office of the company. It normally has or indicates a place where the register of members or debentures holders is currently having to be kept. It indicates the total amount of indebtedness of the company. It indicates or gives a summary distinguishing between shares issued for cash and shares issued for any other consideration, or shares issued for any other consideration. Then it's also be able to indicate the type of the company and its principal main business activities. So the financial statements or exemption statement, where applicable, will actually also to be included. So, so that is just ideally what will actually be contained in this annual return that will end up having to be presented to the register of companies each and every year. The director's report, I've already been able to mention something about it. So I've said it just indicates the prospects the directors have for the company. So how they see or find the future to look like. So are they hopeful about the future? What makes them to be hopeful about the future? So they'll have to indicate in what we call the director's report. So as the annual accounts or annual financial statements are having to be presented to the directors, so also what will come forth is exactly the director's reports, which are still at the same case. In this case, it will have to be read out probably at the annual general meeting. The same case as why in this case, the auditor will be able to present the audited annual financial statements. So directors also have to give their own reports. So the directors shall include in their reports for financial year the names of persons who at any time during the financial year were directors of the company, and of course the principal activities, the principal business activities of the company likely also have to be indicated. So in this director's report, as I've already been able to indicate, it gives like a kind of like a business review. So how the company has performed, what I mean by business review there, it is how the company has been able to perform and what are like kind of like the prospects they could be having for the future. So it is the directors having to do what? Present to the shareholders by having to explain to them. So the business review by directors in the directors report will, for example, in this case, elaborate on the description of the principal risks associated with the entity or company, development and performance of the business of the company during the company's financial year. So what are the developments? What are the new things? Maybe they introduced a new technology, there was a new product board, like that. So that's basically what will likely be contained in the director's report that is normally presented. So maybe sometime or maybe later on, probably you could have already been able to learn about it. So in auditing and assurance, we'll be told, so we can be able to have the annual financial statements. We can be able to have the director's report. Then apart from the director's report, you can have what we call the chairman's statement. The chairman's statement. So the chairman's statement is simply a statement by the chairman of the board of directors. So that is a statement by the top guy in terms of the strategic positioning of an organization. So sometimes in this case, you can actually also be the one who can actually basically be called upon to prepare and present the chairman's statement. So you can have maybe in this case, the auditor's reports. We can have in this case, maybe director's reports. And of course, also you can be able to have the chairman's statement. The chairman's statement. The chairman's statement. So questions surrounding this area, they majorly test on, for example, what are the components of an income statement. So they'll just revolve around what basically entails accounts in an organization. Accounts in an organization. For example, they can ask what are the components of the consolidated financial statements. So you have to, in this case, realize very fast. So I need, for example, indicate exactly what the examiner wants me to maybe provide as maybe the components of consolidated financial statements. That is maybe the consolidated income statement, consolidated maybe statement of financial position. So you'll have to, in this case, for example, elaborate or maybe explain on them. In any case, for example, they have asked the question, and of course, they have put like maybe 3 marks. So 3 marks indicates you have to write a bit more about what has basically been tested there. So investigation into the affairs of a company. So we can wind up by looking at this particular area, investigation into the affairs of the company. So sometimes the affairs of a company can actually be investigated. So just from the word investigate. So most of the time when you hear the term investigate, then in Kenya, we'll think more about what the DCI having to carry out investigations, maybe pertaining to a murder case or something. So the same case here, company affairs can also be investigated. And when they talk about investigation of company affairs, then it simply means wholly looking at the affairs of the company and investigating on them. For example, you can be able to investigate and check out on, for example, who are the members of the company, which kind of business activities does the company undertake, who are the business associates of the company, who are the suppliers of the company, who are the customers of the company, what basically entails with regard to the employees of the company. So that's having to carry out what company investigations. But the investigations won't just happen. There must be a reason as to why they're having to happen. So probably in this case, someone has been able to petition the court. And of course, the court has deemed fit that according to what has been provided as information to them, then the company should actually be investigated. So there has to be someone having to petition the court, just the same case like in this case under liquidation, compulsory liquidation. It doesn't just come like that, the court declares, but of course now in this case, someone has to petition the court, provide reasons as to why in this case the affairs of the company have to be investigated. So the reasons that can actually be provided would be, for example, where the company is being conducted with an intention to defraud who? The creditors. Or maybe if the company was formed for fraudulent or unlawful activities, then the affairs of that company can be investigated. Then if the company members have not been given all the information in respect to its affairs, then if it is in the public interest also that the affairs of the company be investigated. So overall, generally, these are the circumstances that could end up having to lead to a company affairs having to be investigated. So someone will end up having to bring these reasons before the court, and of course the court evaluates them. Then eventually, if they deem they are quite okay for the company to be investigated, there'll be the appointment of an inspector to carry out the investigations of the affairs of a company. So those ones who can be able to apply to the court by providing a number of reasons could be maybe the Attorney General. It can be the members, just one of the members of the company. It can be the company itself. It can be the company itself. So these are basically the parties who can be able to petition for what we call investigations of the affairs of the company. Maybe if I could just be able to ask, as you're talking about having to petition, so who are the parties who can petition for compulsory liquidation? Maybe you can mention to me those ones. Who are the parties who can petition for a compulsory liquidation of a company? Who are the parties? You can be able to mention them on the chat. Who are the parties who can petition for compulsory liquidation or compulsory winding up? So I can see you are saying shareholders, I can see you are saying creditors. That is very correct. Very brilliant, very brilliant. Kezia creditors, Dennis creditors. So I can see you are saying the NYAMO, so the court can't petition because it is the one that having to be petitioned to. So the court can't petition. So it can be creditors, it can be members of the company, it can be members of the company, it can be the attorney general. So you don't have to forget. You have to remember. Those are the parties who can petition for compulsory liquidation. So the same case here, we have also petitioners. One of the petitioners here under company investigations, it is the attorney general, the members, and of course the company itself, maybe through a company meeting resolution. So investigation by the attorney general. So under the Act, the Companies Act, it is provided that the attorney general can order investigation where he has reasonable grounds to believe that the investigation should actually be undertaken. And part of the reasons as to why in this case this could end up having to happen, just repetitive of what we've already been able to look at, if the business of the company is having to be conducted in an unfair manner and end up having to defraud maybe the creditors or members. So that could be a reason. Then another reason, it could be, for example, where the company was formed for fraudulent or unlawful activities. It could be that the company's members have not been given the required information from the company. Then it could be that it is because of what public interest that the affairs of a particular individual or a particular company actually be investigated. So the affairs of a particular company be investigated as a result of that. If there's actually an application by members, then we're not talking about ideally just having to be all the members, but those ones who can be able to pull enough quorum to just be able to meet like a tenth of, or basically be able to control like a tenth of the issued capital, then you can be able to petition. You can be able to petition for compulsory, not compulsory, but in this case for investigation of the affairs of the company, investigation of the affairs of the company. So you're thinking in the case of a company having a share capital of not less than 200 members, or by members holding not less than a tenth of the issued shares. So if there's a company having share capital, then this is the criteria of having to choose who can be able to petition. So in case of a company not having a share capital, a tenth of the total members of that company, because there are those companies limited by guarantee. So they don't have what? A share capital. So for them, go by having to do what? Use the number of members. So it has to be a tenth or more. Then application by the company itself. So this one can actually be through just a company resolution, whereby it is passed by the company. Then eventually it is deposited with the courts to seek for the affairs of the company to be investigated. So what are the powers of these inspectors appointed? So an inspector appointed pursuant to the application of the application for investigation by members or the company has discretionary powers to investigate the subsidiaries of the company or maybe even forward subsidiaries. So under the Act, it empowers an inspector to apply to the court for attendance and examination on oath of any person he would not otherwise be entitled to examine. Then, so overall, or on conclusion, the inspector is required to make a written report to the courts. So at the end of, for example, having undertaken the investigations, then there's the requirement that in this case, that inspector will be able to prepare a report and hand over probably to the court. But of course, there are other parties who, in this case, they are called upon to be present when this kind of report is having to be issued by maybe the inspector. So in this case, the report will basically also be accessed or basically be given to the company itself, to the registrar of companies, to any person who is a member of a company at a fee, anybody corporate dealt with in the investigation. So now in this case, when the investigations are having to happen, they'll probably in this case be mentioning that there are mention of certain parties. There'll be a mention of certain parties. So these parties were actually mentioned will have a right, for example, get a copy of this kind of maybe report. So under the Act, a copy of a report certified by the Attorney General is admissible evidence in any legal proceedings in relation to matters contained therein in that particular document. So if the report discloses any offense in relation of the company for which any person should be criminally responsible, the court is required to refer the matter to the Director of Public Prosecutions. Then you can be able to prosecute the matter or the case, the matter or the case. So that's ideally what we mean by what company investigation. So be very keen with these areas I've highlighted. So these ones are highlighted. Be very keen with them. So they are the ones that in this case have really been tested in the past. So this question is this particular topic sometimes is usually a bit common. So you have to be keen about company investigations affairs, investigation of its affairs, investigation of its affairs. So ideally, that actually marks the end of the syllabus coverage. So I don't have anything else to ideally add on. So that marks the end of the syllabus coverage, unless you have any burning question. So the forum is open. You can ask a question. The forum is open, but basically you are done and dusted with the syllabus coverage. So that is the end. That is the end. So I don't think I've left out anything. So I've tried my level best. So now in this case, the ball is actually in your court just to be able to fine tune the areas you feel like you don't actually understand. You have to catch up or check out with all the revision videos we've been able to share. They're not just for the sake, but they can be able to really help you to prepare for this crucial exam. So you must actually be able to catch up with them, check on what is happening. You also have the notes. You have to be able to go through those topics you feel like you don't actually properly understand, like a kind of like a recap. So that is what basically we've been able to learn. So I don't know if there's actually any question. You can ask any question about maybe the syllabus coverage or something. So you can invite any questions about the syllabus coverage or any question you have just generally you can ask. Any question you have generally you can be able to ask, just ask. I can see Kevin. Kevin is asking, classes will only be revision now. So we'll just be doing revision. And we are ideally going to start from topic number 1, so up to the last topic. We do a revision of the case laws. So someone wants us to do a revision of the case laws. Someone wants us to do a revision of the case laws. Okay. Any other concern? Any other concern? can we see, there's another concern here. Are there key topics in company law? There any accelerated revision classes? So the only accelerated revision class is the one that I'm having to provide on Tuesday lunch hour. So that will still actually basically remain constant. It will remain constant up to the end of the semester. But what I know, the remaining classes we have, they are quite enough. They are quite enough to do so much revision. So if we can do, there are like 8 classes still remaining, because if we can be able to check the calendar, so we have this coming week, the other week, then this coming week, then the other week, then. So still have like 8 classes, 8 normal classes. Then of course we have revision classes for lunch hour, like 4 of them. So that would be quite enough to, I think, be able to peruse through the syllabus. Of course, cover almost each and every area that is probably end up having to come in the exam. Another query, so let me answer all of them. Are there key topics in company law? So what I can be able to advise, you can focus on. So there are those areas I've been able to highlight. They're not be very keen about them. Focus on them. So in company law, they don't specifically test specific topics. They test across the syllabus. So you are far much safer if you have knowledge in all the topics, because they test across the syllabus. So they won't test specific topics. They test across the syllabus. They test across the syllabus. You are far much safer if you have gone through the whole revision, So in those notes, I've been able to highlight a number of areas that I feel like they are very key. Be very keen about them. Be very keen about them. I've already emphasized the super highlighted areas. The super highlighted areas in the notes are very key. Questions will end up having to come up from those areas I've been able to highlight in the notes. So if you are keen about them, then rest assured, when you go into the exam room, you'll find questions having to come from those areas. So you have to be very keen about them. Another thing is, are we done with all the topics? Yes, we are done with all the topics. We are done with all the topics. I don't think there is an area I haven't been able to touch with regard to the syllabus. So we are done with the topics. We are done with the topics. You can also point to us any area which is likely to be in the exam. Any area which is likely to be in the exam. So be very keen about those areas I've highlighted in the notes. So the examiner will test across the syllabus, but be very keen about those areas I've highlighted in the notes. Be very keen about them. Be very keen about them. So how will the revision be done so that we can prepare? So the revision will be done topically. So we'll start from topic number 1 on Monday as we go across the board, up to the last topic. So we'll touch on all the topics. We'll touch on all the topics during revision, but we'll start with the topic number 1. So we go through topic number 1 on Monday. I'll probably end up having to go even up to topic number 2, because I'll just be picking probably the key areas I feel like they can be tested. Those are the ones I'll be able to emphasize on during the revision. Bridget says lunch hour she won't be able to make it. So we only do 30 minutes. So 30 minutes, and those ones who have attended the session, they know. So we don't go beyond 30 minutes. So if you miss out, you can, because I post them immediately on the LMS. So you have to log into the LMS to get them. So I post them. I've posted all the ones you've done in the past. I've posted them. So get them on the LMS. You get them on the LMS. So, and they don't go beyond 30 minutes. So it's something you can spare. You can't spare 30 minutes in a day to watch. Probably you have a very hectic day. So I don't know what can happen. So, but it's 30 minutes. Is it even per day? 30 minutes per week. 30 extra minutes per week. So those classes, I cannot do away with them. So they have to be there. So that is what has happened. Like for the last, is it 4 semesters? So you have to change the culture. I don't. It's hard for us to change. So those ones who have attended my classes, they know that we've done those classes like the last 3 or 4 semesters, and I know what those classes do. So experience is the best teacher. Experience the best teacher. I know what those classes do. They help this. There are those students who really like them, so they help them a lot in terms of having to prepare for the exam. So they just work magic. They just work magic. So we'll still do them. So it's just have like 4 of them. We'll still do them. Another question. You give us predictions. You give us predictions. My predictions is just be keen about what I'll be able to teach you during the blocks. Just be keen what I'll be able to teach you during the blocks. And of course, I've already been able to give you predictions. So I've really emphasized just be keen about those areas I've highlighted in the notes. I don't know which kind of prediction you want me to give you. And if you look at the notes, if it is like maybe 10-page handouts, I've highlighted like maybe 6 or maybe 5 areas. So which kind of prediction you still basically expect me to give you? So that's why in this case, I'll tell my students, you have to listen to the teacher, to the latter. What is this teacher having to say? So hope you're getting my point. Hope you're getting my point. Let's have revision classes, GOD, normal classes. Okay, I think that one I've been able to answer. Yes, those who won't make it will attend. To attend can actually watch the video later. Watch the video later. So there's Bridget. You'll have to stretch and spare some 30 minutes to watch the video later. So Bridget will have to stretch and just spare like 30 minutes to watch the video later. Yeah. Any other concern? Any other concern? Any other concern? Like, for example, the one who's asking for prediction. So, you know, you can be able to see this area I've highlighted. I've highlighted here the parties who can petition. I've highlighted here under application of members I've highlighted, because now in this case, under the question they can be able to ask is the threshold under which members can be able to petition for investigations of the affairs of the company. You must be able to know these ones. In fact, this question was actually tested sometimes, so I can't tell the exact thing. So you have to be keen. So the parties who can be able to petition, and of course also the reasons. Then of course, you can be able to say I've highlighted those ones who are entitled to the report after investigations. I'm not highlighting just for the sake. I'm telling you this area, in fact, this area of investigation, something is telling me that it will be in the exam because they haven't tested it. Like the last, I don't know, the last sitting it was not there, the other sitting it was not there. So this one they are likely to test it. This area of investigations, they're likely to test it. So I've just highlighted those areas I feel like this one they can easily test them. So you can be very keen when you're having to go through the handout. So you can see this handout I've highlighted just part of the key areas that I feel like in this case they can be able to test. So when you're basically going through, you just have to be very keen. But of course, also take note of what we'll be able to revise during the blocks. Just be very keen about what is happening during blocks. So, and of course, now in this case, as I told you, this paper will be very easy. So you don't have to start having panic modes here. You just have to be relaxed. Just be calm. Just be calm. If you've basically been following instructions in class, the paper will be very easy. The paper will be very easy. And of course, you've basically been following up with what is happening in terms of revision. So you don't expect the paper to be that so hard. There are, of course, those ones who are fearing. I don't know why people fear company law. You don't have to fear. It is an easy paper. So can you really compare company law to auditing and assurance? Can you really compare company law to auditing and assurance? Can't compare. Auditing and assurance, it is tricky. It is tricky. It is tricky. Auditing and assurance is actually very tricky. A lot of content. Is it 17 or 18 topics? A lot of content that is actually there. Procedures, left, right, and center. To be able to understand what is happening in terms of assertions, what and what and what. But now company law is actually a bit, these are very fair paper compared to the auditing and assurance. So just basically follow up with what is happening during blocks, because we'll cover the whole areas that in this case we feel like can actually be tested. And of course, now in this case, utilize the handouts we've been able to give to do the revisions, going through them. If you remember, these things won't stick just like that. You basically have to do like a kind of like repetitive review to be able to like comprehend and actually understand them so well. So once you can be able to do that, then I think you'll be able to pass. You'll be able to pass. Another area I can be able to highlight it is that I've said it several times that in this case, you have to be keen about the topic of formation of companies, be keen about the topic of shares, be keen about the topic of share capital and debt capital. So these are the topics unaweza pitia tu juu, but hizo I can basically advise you to like go through them thoroughly, very thoroughly. So formation of companies, shares, especially formation of companies, share capital and debt capital. ISO, like you go through them very thoroughly and understand what is happening in these topics. These other ones, maybe you can miss out on one or two things, but those ones I can advise you. It's like you'll be able to read like word by word as you revise, word by word as you revise. So formation of companies, share capital and debt capital, then add maybe shares like that. So if you are basically comfortable in those topics, these again as a where you'll just be picking the marks as you basically top up. Because if the exam comes, there's a higher chance that you'll have a difficulty in answering questions from these topics. In the exam, probably if you've not prepared so well about these topics, you'll have a lot of difficulties having to answer questions related to those topics. Formation, share capital, and debt capital. There's a higher chance if you're not so well prepared in these topics. But these other ones, I can guarantee you probably will have something to write. Because you can see the content is not that so much. Very little content, so you can be able to recall very fast what was happening in these other topics. So if you are so quite well conversant with formation, share capital, debt capital, then you just add on even shares. Then you tell the examiner you can do what you can come. You can basically bring the exam. You can basically bring the exam. So, and once you basically top up with what you'll be able to revise during blocks, then why should you fear the exam? You shouldn't actually fear the exam. You should just need to be relaxed and of course calm. But in this case, what I've basically been getting in this class, I'll be able to pass this paper. I'll be able to pass this paper. There'll be no magic in the exam because what I'm teaching you is what you basically see in the exam. That is what you'll see in the exam. That's why I'm telling you, you need to follow up with what this teacher is having to say. What is this teacher saying? You must have a key here because I'm telling you, what I'm teaching you, what I'm emphasizing on, it is what will appear in the exam. There'll be no magic. There'll be no magic, nothing that will be strange there. You just see what we've already been able to cover and what we've been covering in class up to the last day. What you've been covering in the class, you'll be able to see it in the exam. So you'll be able to see it in the exam. So that is what I can be able to advise. I can be able to advise. So that's it. That's it. So let's meet on Monday. Let's meet on Monday. So we'll start from topic number 1, like that as we go slowly by slowly. until we finish up with the whole syllabus revision, So I don't know if there's any other concern, so let me check the last time. I haven't talked about administration. Administration is the same as receivership. So administration and actually receivership, not so much difference about the two. It's just the same. So what you've been able to cover under receivership is same as what you can be able to say it can actually be covered under what we call what administration. So we can say the company has, for example, been put under what administration, or the company has actually basically been put under what we call what receivership. So these two persons, the administrator, or maybe in this case the receiver, they'll be able to undertake just the same. They'll undertake the same thing. So, for example, the administrator will likely end up having to come into the company and, of course, take over the operations of the company, take over the administration of the company for the benefit of who? Maybe the creditors. For the benefit of maybe the creditors, he'll administer the company. So that is what administration. So it's just the same. Administration and receivership, just the same. So administrator is actually appointed to come into the company to take over the operations of the company, to manage the company for the benefits of the creditors, to salvage all the assets, identify all the liabilities in terms of the creditors and be able to do what? Settle them. So it can depend. For example, now in this case, if you want to pay the creditors and of course the company continues operations, then that is actually still quite okay. Or for example, now in this case, you can be able to undertake the administration and of course now in this case, maybe enable or facilitate the company having to continue in operations. Then the company can be handed back to the directors. So receivership and administration, so just the same. What we covered under receivership is what you can be able to say it's exactly under administration. Any other question? Yeah, so if there's no any other concern, then I think we can end there. So we'll meet on Monday, then we start our block revision. So just be ready to at least try your level best to attend them because they will help you. They will really help you.